views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
Welcome to today's verdict. I'm your host and trial attorney, David Lesch. We had three distinct topics covered today. I think you'll enjoy all of them. First one we're going to be talking about guns and the concealment of guns and whether or not you have a right to walk around New York with a gun, considering the Supreme Court did recently come down with a decision. We're going to have a state senator on, Kevin Parker, who will talk to us a little bit about the carry and conceal law. That'll be on. Next up, we're going to be talking with an expert on sick and paid leave and what you need to know as to whether or not you're going to have a certain amount of hours that you'll be able to take during the year. And lastly, we have an attorney on who's going to be discussing the FOIL request, Freedom of Information Act, and what you can get when you're asking for disciplinary records in terms of New York police. Very interesting show, a lot to get to, so stay tuned. Today's verdict starts right now. Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesch. We have with us today the supervising attorney at the NYCLU, Bobby Hodgson. Bobby, thanks for being here today.
Thanks so much for having me. Good to talk to you.
We're going to talk about police records and the ability to be able to find out a little bit behind the scenes in terms of misconduct. But before we do that, let's talk a little about the history of 50A. If you could do that for the viewers, I'd appreciate it.
Sure. So in New York State, to start with, we have a Freedom of Information law that by default makes public any records of public agencies, including those to do with public employees like police. But since the late 1970s, there has existed this law, Civil Rights Law Section 50A, that essentially created a complete shield that mandated the confidentiality of everything that was defined as a personnel record. For law enforcement officers, for police, for corrections officers, et cetera. This was a law that we can argue about why it was passed in the first instance and whether perhaps it should have been more narrowly interpreted. But for many decades, this completely shut the public out from understanding how the investigative process works when a complaint is filed against a police officer, about when discipline is imposed and when it's not, about how any of these types of inquiries take place. And following the murder of George Floyd in 2020, there was a public outcry, obviously about many different things to do with police reform and police accountability. And one thing that came out of that was in New York State, the legislature repealed 50A. It completely removed this law from the books in June of 2020. And
now, when we talk about the police, there are so many different types of police. Are we talking about New York State troopers? Are we talking about New York City police? Are we talking about, there are so many different types of law enforcement. Who are we talking about?
This is about all of them. This is a law that had completely shielded records as to local cops, state police, corrections officers in jails and prisons. And then with the repeal of 50A, the legislature removed that shield. And so now that, the governing law is our state's Freedom of Information law, which is a general law that by default makes a lot of records public, and then creates certain very narrow limited categories where things might be redacted or might be withheld, but only based on some very specific justification.
I want you to know, for my career as an attorney, many times I bring police misconduct cases and everything's redacted. If I'm lucky, if I get anything on a piece of paper, but now things have changed. I understand that you've had to go to court to enforce your right to be able to get these records. First, let me ask you why you've had to go to court and how you've been doing that.
Sure. So unfortunately, with the repeal of 50A, what the NYCLU did is we immediately filed Freedom of Information law requests at over a dozen jurisdictions around the state and in New York City, seeking decades of misconduct records to understand how these complaint processes work, who's getting investigated, whether discipline is ever being imposed. And in response to that, unfortunately, overwhelmingly, these police departments, these municipalities have thrown up every obstacle they can to prevent the release of records. They've tried to reimpose 50A under another name. They've tried to slow roll these requests by not responding or by saying, we'll get back to you in 2 years. All sorts of things have happened. And so when we're faced with that, we have to go to court to vindicate our rights and the public's rights to see these records that the legislature specifically said now everybody gets to see.
So when we're talking court, are we talking state court? Are we talking federal court? What are we talking about?
Generally, these come about in state court. We're bringing our lawsuits in state court because it's a state freedom of information law. But I should say one of the first things that happened here was the New York City, the policemen's union ran into federal court on day one when they realized that the New York City CCRB was about to release hundreds of thousands of records to the NYCLU, and in fact already had. And they tried to get an injunction from a federal judge saying you cannot make these public. That went all the way up to the Second Circuit on an expedited basis, and the Second Circuit said absolutely not. And so those CCRB records were made public. Yes, the NYCLU has a searchable database so that you can see hundreds of thousands of CCRB investigations.
But there must be a lot of other investigations that have taken place that are not in the hands of the CCRB.
Exactly.
And the question is, how are we going to get those records?
We've asked for them and they're litigating.
And they say no, and they say this is why. And from what I understand, because we talked a little bit, you and I, off camera, a little bit about the retroactive nature of these records. And that seems to be a problem. Am I correct?
That is one of the many problems. So one thing that departments have said, I should be clear, New York City didn't say this. This is maybe a more niche argument that's been brought up, for example, in Rochester. And what they've said is, okay, going forward after June 2020, there's no more 50A. But for every record in existence from before June 2020, we don't have to turn it over because 50A still shields it.
Now, you would think this should have been covered in the law. And yes, in law school, you learn that you have to sometimes go back to the hearings and decide what the intent was in the initial bill. But this is just so clear cut. From the day the law is imposed, is it retroactive? Can we get records from officers who were disciplined 2 or 3 years ago? Why was this not mentioned in the law, or is it just so clear cut that it should be covered?
It is so clear cut that it should be covered. And please stop me if I'm getting too far into legalese, but retroactivity actually has nothing to do with this. The idea is we are making a request in the present day. It's after June 2020. So according to our FOIA law, every record you have as a public agency, regardless of when it was created, if it's from 50 years ago or if it's from 2 days ago, it's in your possession and you have to turn it over in response to this request I'm making here and now. And it used to be the case that 50A existed as a barrier to that. They could say, oh, well, 50A prevents me from releasing these police records. But today, 50A does not exist. This is not about the retroactive application of 50A.
So have you been successful in the lower courts?
Again, the majority of lower courts have agreed with our position. The case I mentioned in Rochester is one where a judge did accept this argument and essentially prevented the release of records from prior to June 2020. That is up on appeal. We are litigating that case before the Fourth Department this fall.
It looks like it's going to have to keep going all the way to the Court of Appeals for you to finally figure out what the situation is. And who knows, it may even go farther than that. We'll see. Any final thoughts? Listen, we're moving in a direction in this country, or certainly definitely in our state, to be able to get these types of records and to hold police more accountable. Do you see that trend continuing?
I think so. I think there is a growing, dawning understanding that this type of transparency is the first step in many, many required steps to start to address police reform. But all this is shining a light on what is going on without seeing the investigation records, which ones are being abandoned. When is it that a recommendation for discipline is being ignored by a police department? When are there 35 different complaints about the same type of behavior against one officer? Without first seeing that, there's nothing that can be done about the next steps of saying, okay, well, what are we going to do about it? So, with the repeal of 50A, with similar laws that have happened around the country, and I should point out that there is a growing consensus around the country that making these types of records public is something that should have happened a long time ago, and that in many places it has been happening for quite some time.
We're going to leave it there. We're kind of running out of time, Bobby, but
Sorry.
you summed it up very, very well. And we love your organization, the work that you do. Maybe you can come back on in the next couple of months and let us know how these cases are faring.
I'd love to. I hope I have good news for you. It's always good to talk to you.
All right. All right. Well, stay with us. Today's verdict has so much more right after this. Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesch. We have Claudia Henriquez here joining us. We're going to be talking a little bit about sick leave. Claudia, how are you doing today?
I'm good. How are you?
I'm well. Let's first tell the viewers a little bit about the difference between, let's say, annual leave and sick leave. How would you define annual leave and how would you define sick leave if you could?
So sick leave, and to use the appropriate term in New York City, it's paid safe and sick leave, is a benefit that applies to all workers who work in New York City. And that applies regardless of immigration status, regardless of whether the worker is part-time or full-time, to all workers in the private sector. So it does exclude government employees, but everyone else is covered. And it allows workers to use time off for their own illness or injury, or to take care of a family member who has an illness or an injury, and also for what's called safe leave, which is to seek assistance when the worker or their family member has been subject to domestic violence, trafficking, assault, or certain other crimes that are listed in the statute. So that's a benefit that's afforded by the city to all workers. All employers have to comply with it. Annual leave is optional if a worker is working for an employer that chooses to provide more than what the law requires. We encourage that, but it's not required. And the amount that workers are supposed to get is depending on the size of the employer. If it's less than 100 employees, then it's up to 40 hours each calendar year. And if it's more than that, then it's 56.
Let me ask a question. When did this law go into effect?
The law went into effect on April 1st, 2014.
Okay, so it's been around for a while, but there's always amendments and there are always loopholes. Let's talk about a little bit in terms of how COVID plays into this, because are you considered to be sick if you have COVID? Obviously, the answer is yes. How much time do you get? Do you have to show proof that you've had COVID? What are the ramifications about COVID-19?
Sure. So there's actually a separate law that is administered by the state that applies for workers who actually get COVID. And so depending on the size of the employer, it can be up to 5 to 14 days, and that's through the Department of Labor. And that's different from our law. So if someone gets COVID, that actually should not eat into the amount of time that they get under the New York City Act.
So it's extra time. It's not included in the usual amount of time. Wow, that's
exactly. So the one thing though that I'll add is that if there is another reason related to COVID that doesn't quite fit squarely in the state law, for example, the place of business is closed because of COVID, that is a reason that someone could be able to use sick leave under the New York City law. Also, if they are, let's say they have some symptoms, but they're waiting on the results of a PCR, so it hasn't been confirmed that they have COVID, they would be able to use their New York City time.
I understand also if you're looking to get vaccinated or you want your child to get vaccinated, that may also have something to do with how much sick time you might be getting.
That's correct. So there's actually two laws that apply to individuals who want to get vaccinated. So the state passed a law that requires employers to give every individual, every worker, up to 4 hours per shot of paid time off for their COVID-19 shot. That's through the state. That should not affect whatever sick leave the worker has under the New York City law. New York City amended its law in December of 2021, retroactive to November of 2021, to allow workers to take time off paid, same 4 hours per shot, to take their children to get vaccinated. And one of the things that I want to highlight is that, this passed at the time that the vaccine for the 5 to 11 age group was approved, and now recently the vaccine for children as young as 6 months have been approved. And so, parents of very young kids now have this benefit as well.
All right, Claudia, let's, put our employer's hat on here because it's different for each employer. Employers with 100 or more employees must provide up to 56 hours of paid leave each calendar year. Am I correct?
That's correct.
Okay, so you got more than 100 employees where you work, you get 56 hours of sick leave really a year, or whatever you want to call it. Employers with 5 to 99 employees, they get 40 hours of paid a year, correct?
Correct.
All right, so that's very important to know. And by the way, this is paid. This is not non-paid. You get paid. You still get paid. Employers with 4 or fewer employees and a net income of 1 million or more, you get 40 hours of paid leave, correct?
That's correct.
Now, here's the part that I'm a little confused about, because net income of a million or more. So that is, let's say you gross, 2 million, but you have taxes and disbursements and everything else, you're down below 1 million for net. That wouldn't apply, correct?
Theoretically, I think those cases would be our office would treat them on a case by case basis. So we would look into if someone was claiming, hey, I didn't make up to $1 million, we would look at their financial records and make that assessment.
Okay, and the last one, which I thought was important, the last one that I'm going to talk about, employers with 4 or fewer employees and a net income of less than 1 million, they still have to provide 40 hours, but it's not paid, but they have to give the 40 hours, correct?
That's correct.
So what's the impetus for this? Is it just to give more people time to heal? Sometimes it's with money, sometimes it's not even with money. What was the impetus for this particular law that changed in 2014?
Right. So I think the intention is to carve out small businesses. So recognizing that it can be it's an additional expense for a small business to provide paid leave to employees. The city created this criteria to sort of define like what constitutes a small business. And so there is a little bit of flexibility there in that the leave does not need to be paid, but the employers still need to comply with the other aspects of the law, which is to give workers a policy, not retaliate when the workers take time off and that sort of thing.
Is there any pushback that you're getting from employers? Are there cases that have been filed in court? Are there any type of
we get hundreds of complaints each year. And it can vary from I think our one of the issues that we see most frequently is retaliation. So unfortunately, people getting fired or demoted or otherwise, written up or any of those things for taking time off.
And lastly, before we let you go, is there some place that a viewer could go to see all this instead of listening to the show again? Because it's fairly convoluted. Where could they go to get a whole list of requirements?
So they can go to our website, which is nyc.gov/workers. And I just wanted to make one quick plug, which is that there is an exception to the small employer, which is employers of domestic workers. So if you have a domestic worker, that's a change in the law that went into effect in 2020. Now domestic workers have to get 40 hours paid, regardless of the size of the employer.
Claudia Henriquez, thanks for coming back. I think you've been on before, and it's a pleasure to have you back. Please come back with anything else. Your organization does such great work, and hopefully we'll see you next couple of months.
Thank you. Have a great afternoon.
You too. All right, stay with us. Today's verdict has so much more right after this. Hello, welcome back to today's verdict. I'm your host and trial attorney, David Lesch. We're actually welcoming back to the show State Senator Kevin Parker. Kevin, thanks for coming back.
Thanks for having me. I appreciate it.
It's our pleasure. All right. So I know there was almost, I don't call it an emergency session, but certainly the Senate was called back fairly quickly, and there were at least 2 different bills, that we were going to be talking about today. One of them has to do with guns and the ability to walk around with these particular guns, either concealed or not concealed. Tell the viewers a little bit about this legislation.
Yeah. Well, first of all, we got called back by the governor. The legislative session usually is about 6 months in the state of New York. It's from the first week in January to about the first week in June. Shortly afterwards, we had a kind of out of control Supreme Court that struck down a number of important, what we thought was established and settled law. And one of which was the concealed carry permits that really we don't allow in New York City, particular. New York State generally, but New York City in particular, concealed carry is just not a thing. Obviously, the largest city in the country, over 8 million people. On a Monday morning, you can have upwards of 15 million people in the city of New York. And so having a number of people walking around with firearms, just not what we think should be happening. So the governor had called us back, not just the Senate, but the entire legislature, and back into what we call the extraordinary session, right? And we dealt with really two issues, both the issue of concealed carry, which we thought we had really dealt with in terms of guns. The state of New York is already the third safest state in the entire country as it relates to gun violence. Still not nearly as low as we like it to be, but we really thought we had done a great deal, especially with our early legislation on guns going back a number of years. And so we came back, we did essentially brought some legislation together. The basis of the legislation we passed was actually two bills that I had written already. One was a training bill about how you receive a gun permit. It was really based on the Japanese model. Japan actually has the most restrictive gun laws in the entire world, and we really based our bill on that. And the governor used that as the base of her bill, and then added a bill that I had worked on with now mayor, but at the time borough president Eric Adams, on making sure that we looked at people's social media before we gave them a gun permit. We wrote that legislation in the wake of the horrific attack on the synagogue in Pittsburgh about 3 or 4 years ago, and that legislation came due, and so that became also a part of the bill. They also added some other provisions to it, but those two pieces of legislation that I originally wrote, going back to 2018, were the basis of this new legislation that we wrote.
I think a lot of people are confused, though. What is the current law with respect to carrying a concealed weapon in New York? Just so everyone's clear.
Right. So essentially, we did not allow carry concealed permits in the city of New York outside of law enforcement. And that law was essentially struck down by the Supreme Court. So what we did is that, again, using my training bill as the basis, we created a new law that was signed by the governor that essentially provides very stringent, training around, guns and gun carrying, but then also limited the places in which you can have a gun, even with the concealed carry permit.
With the second bill, or at least with the bill that had to do with the equal protection law, who are we trying to include in that particular provision under the Constitution, and why was this particular bill put forth?
Yeah, another area that the Supreme Court struck down, as we all know, was Roe versus Wade, which essentially is a privacy bill, but also specifically deals with the issue of a woman's right to choose. And essentially what we did is an equal protection amendment. And so with a amendment to the Constitution, we want to really guarantee a woman's right to choose in our state constitution. It is a long process. It requires the legislature to pass it in 2 consecutive legislatures and then have a referendum by the voters. And so passing it now means that there's an opportunity for us to pass it again at the beginning of 2023, and then the following year to bring it for a referendum in front of the people, and hopefully it will become an amendment to the state constitution and really enshrine for the women of the state of New York that they have a right to choose on what happens with their bodies.
It almost seems like New York is trying to protect certain rights that the Supreme Court seems to be taking away. Is that how you see, the sessions moving towards? In other words, making sure we do a little added protection?
Absolutely. Look, this has been something we have been working on for a number of years. It's not a new situation for us. We knew after the election of Donald Trump as president, and then subsequently, 3 new conservative justices, that we would get a very different Supreme Court. We were hoping that it wouldn't get to this, but we certainly anticipated it. And there's a number of laws that we have done over the last number of years to strengthen our laws around the Second Amendment, to strengthen our laws around a women's right to choose, to make sure that the franchise and voting rights are protected in the state of New York, particularly for Black and Latino communities. And there's probably more for us to do as we go forward.
Well, I was going to ask you, what else are you working on? What else do you have cooking, things that you may be moving forward with? What are the thoughts?
Well, as you know, I'm the chairman of the Energy and Telecommunications Committee and the leader on the issue of climate change and the crisis here in our state of New York. We just passed 2 bills that got signed into law this year, one around geothermal systems and decarbonizing buildings, and another around appliances and making sure that the state of New York is doing the best it can around having energy efficient appliances. But certainly the issue of the climate change crisis and making sure that we have sustainable energy in terms of generation, making sure our transmission lines are where they need to be, and making sure that the interconnection between this new generation utilities goes forward is all at the top of our list. But there's lots that need to be done. We need to train every single New Yorker in the state around the issue of demand response and knowing kind of when to use energy and when not to use energy. We also need to make sure that we have, clean, cars, and sometimes going to be electric, sometimes going to be low emission vehicles. But we have about 2.5 million vehicles that we really need to, address their issues. And obviously we have an affordability gap crisis in the state of New York. Everything up from gasoline to home heating oil, to natural gas. I recently have submitted a windfall profits bill that would, stop companies that are domiciled in New York State from essentially just, charging us whatever they think they should charge us when they know we're in crisis, and really digging deep into the pockets of New Yorkers at a time when they can least afford it.
Well, Senator, I want to thank you very much. You do some great work. We love having you on. So hope have a great summer. And then maybe in the fall, you come back, you tell us how you're doing. Absolutely. Looking forward to it. All right. Enjoy your summer. All right. Well, stay with us. Today's Verdict has so much more coming up right after this. Well, that's all we have for today. I'd like to thank our guests for joining us, and of course, you, the viewers, for watching. If you have a show or a topic you'd like to see on a future edition of Today's Verdict, just feel free to email me at davidlesch@bronxit.org. Until the next time, know your rights, reach a verdict. See you in 2 weeks.